Parliament is the heart of Canada's democracy. Located in the national capital, Ottawa, it's the country's federal legislature. This means Parliament makes laws that affect the whole country, in certain areas like fisheries, trade, defense, or the postal service. These are things that affect all Canadians, no matter where they live. Parliament has three parts: the monarch, the Senate, and the House of Commons. The Senate and House of Commons are where parliamentarians meet to represent Canadians and discuss and debate issues that matter to them. As well as proposing its own bills, the Senate debates, studies, and refines proposals for new laws passed by the House of Commons. Senators are appointed to represent every province and territory in Canada. They offer regional and minority perspectives on issues discussed at Parliament. The House of Commons proposes, debates, reviews, and passes bills. This is where most new laws start their journey. Members of Parliament in the House of Commons are elected by Canadians like you. Each member of Parliament represents a specific area of the country called a constituency or riding. The third part of Parliament is the monarch. The monarch is the country's head of state and is represented by the Governor-General in Canada. After the Senate and House of Commons both pass a bill, the Governor-General signs it into law. The Governor-General also opens new sessions of Parliament and has the power to dissolve Parliament, which triggers an election. These are just a few of the Governor-General's roles. Together, the three parts of Parliament create new laws and tackle issues that impact the lives of all Canadians.
Hello! In this video, I will be talking about the type and process surrounding the passing of a bill. There are three principal types of bills: government bills, private members' bills, and private bills. Government bills are introduced to Parliament on behalf of government by a cabinet minister. Private members' bills are introduced to Parliament by a private member. A private member is every MP who is not a cabinet minister. This means that any member of the governing party who is not a cabinet minister is considered a private member. Private bills are rare these days, but their purpose is to either confer special powers or benefits on one or more person, this includes corporations, or to exempt them from the application of a statute. Private bills cannot be introduced by a minister and must be founded on a petition signed by the persons interested in promoting it. Examples of private bills include an act to exempt a church from general taxation rules on sale of property, and up until the 1960s, divorces were only granted by a private act of federal parliament. Now we are going to go over how a bill becomes law. In general, a bill becomes law if it is passed through the following stages of the legislative process. There's the introduction, first reading, second reading, committee stage, report stage, third reading, and royal assent. A bill will need to pass through steps 1 to 6 twice, or once in each chamber, before the bill can attain royal assent. Let's begin with the first reading. Typically, at first reading, the bill is not actually read, but is distributed to the members. A short speech may accompany this distribution, or simply an announcement that the bill is receiving its first reading, as seen in this example from a transcript from the House of Commons proceedings. Now for the second reading, which is when the bill is debated. All debates must be focused on the general principles of the bill. However, details of provisions are not debated at this stage. Next up is a committee stage. Following debates at a second reading, there is a vote to determine whether the bill should proceed to committee and which committee it should go to. Depending on the scope of the bill, committees often have lengthy hearings, including witnesses, etc., where they debate the merits of the bill, as well as technicalities like wording. Before going to third reading, the committee that analyzed the bill will report back to Parliament with recommendations. This is called the report stage. As an example, here's Bill C-47 printed at committee stage. The next stage is the third reading. At third reading, the bill is again debated. If passed by the House of Commons, the bill is reprinted again, incorporating any changes made by the House at the third reading, and then sent to the Senate, where it starts the whole procedure anew. Here's an example of Bill C-47, as passed by the House of Commons in June 14, 2007. Next is the royal assent stage. If a bill is then passed by the Senate unchanged, it will be given royal assent. If, however, the Senate makes changes to the bill, those changes must first be voted on and approved by the House. Royal assent is given by the Governor General or his or her delegate. The number assigned to the bill changes to a chapter number. For example, Bill C-47 became SC 2007 C-25. This signifies that the bill, now being law, will be printed in Chapter 25 of the 2007 Annual Statutes of Canada. The bill is then printed in the Canada Gazette, Part 3, on the Justice Laws website, which is part of the Department of Justice website, and in the annual volume of Statutes of Canada. Take a look at this Bill C-47 Royal Assent version from June 22, 2007, 39th Parliament, First Session. Note the assigned chapter number 25. And here's an example of an act respecting the protection of marks related to the Olympic Games, Chapter 25 in the Annual Statutes of Canada. Note the short title, Olympic and Paralympic Marks Act. This is the title that will be used once it is published on the web and in print. Lastly, there is the proclamation stage. In order for a law to enter into force, it must be proclaimed after it has received royal assent. The proclamation typically occurs by order in council. Usually a law comes into force or takes effect on the day it receives royal assent unless another date is set. Keep in mind, when citing a bill, you should use a long title provided during the legislative process. When citing an act, you should be using the short title it is referred to by once it receives royal assent. It is also worth noting that not all bills have a short and long title. In such cases, use whatever title is provided. And we're finished. Please continue with the remainder of the learning module.
Hello everybody, it's Sarah here from Action for Healthy Communities. And this week, we're going to be talking about Canadian law and justice. Justice means to treat people fairly and equally, and when applied to law, it means to judge people fairly and equally in accordance with the law. In Canada, no one is above the law, no matter if you're a politician, a police officer, or a judge. If you break the law, you will be treated the exact same as anybody else who breaks the law. Laws in Canada are based on the Criminal Code of Canada, and they are split into two general groups, public and private law. Public law decides on matters that affect all of society. So under public law, there are criminal cases, which would include murder, constitutional cases, which would be if somebody took away a constitutional right, such as free speech, and administrative cases, which include situations like if the government refused to give you unemployment support. When you go to the court for public law, it's between the government and you. Private law is for crimes that happen between people, and they set the rules for contracts, property, and more. For example, if someone were to accuse another of damaging their property, then this would happen in private courts, because it's between two people, and not between a person and their government. Beyond public and private laws are laws that can be created by cities or towns, and these are called bylaws. Bylaws are created by cities and municipal governments, and they only apply to that community. However, bylaws can only be created for a number of situations, such as animal control, parking, construction, noise, and more. This means that Edmonton's bylaws could be different from Calgary's, so make sure you check before you visit a new community or move there to make sure that you're not doing anything illegally. If you were to break a law, then you could go to court, which is where they try to find out if you did or did not break the law. You can have a lawyer who will represent you and your arguments. In court, you will have a judge and a jury. The jury is made up of Canadian citizens, and they will hear your case and decide whether or not they think you are guilty or not guilty. If you are found guilty, then the judge will decide your punishment. In Canada, it is assumed that you are innocent until proven guilty. This means that until you are proven guilty, you are innocent, and you should be treated as such. If you are curious and want to learn more, you can check out the Edmonton Police Service link that is in the description below. To get in contact with A4HC Youth, you can DM us at AHC_youth on Instagram, or you can phone or text us at 780-235-3581, or you could email us at youth@a4hc.ca. Hope to see you guys next week.